right, and welcome to today's program, How Not to Get Sued, an HR Survival Guide. Our presenter is Elissa Holman. So I will go over the agenda for today. I will be starting with an introduction, and for those of you who do not know me, my name is Joanna Davis, and I am the 2024 GRHRA President. Then we will have the presentation on how not to get sued, an HR survival guide, again by our presenter, Elissa Holman, followed by a Q&A. Some upcoming GRHRA events. So February events, Wednesday, February 7th at 10 a.m. We have our next program, which is Talent Scarcity, How to Hire and Retain a Shrinking Workforce. And this will be a virtual program. Please go out to the GRHRA website and register for that program today. Also, on Wednesday, February 7th at 5 p.m., we have our first member meetup. So that will be an in-person networking event. Now, for this event, you do not need to register. You simply need to show up at the Ridge Social Drinkery in Davenport, Iowa at 5 p.m. to participate. Next, I am happy to announce that we have our third annual GRHRA Ignite HR Conference. It will be on Wednesday, April 24th at the Rhythm City Casino. This is an all-day event. On the GRHRA website, we have fantastic details, including the conference schedule. We also have the full agenda, which if you click, you'll be able to have access the session descriptions and the speaker bios. So make sure to go out to the GRHRA website today. Registration is open, so register for the event. Next, I would like to present our speaker, Elissa Holman. Attorney Elissa Holman is a highly successful and knowledgeable professional with nearly 2 decades of experience in employment law, contract law, litigation, and human resources. At Dickinson Law, Elissa's practice is focused primarily on employment law and civil litigation. Her unique background helps her leverage her extensive business, HR, and legal knowledge for her clients by helping them get in front of an issue in a proactive manner to avoid costly litigation and headaches in the future. Before joining the firm, Elissa spent 3 years as a litigator in employment law, personal injury, and defamation law. She was named a Rising Star of the Great Plains for her work by Thomson Reuters in 21 and 22. Prior to becoming an attorney, Elissa climbed the corporate ladder of Bank of America for 16 years, where she held various roles as a senior vice president in the HR arena. Her predominant focus during her tenure was in leadership development, executive coaching, training and development, and assisting in the direction and execution of HR operational processes and services for more than 200,000 employees across the globe. She has also served as a consultant for Fortune 500 companies focusing on the customer and associate experience. And now I will turn it over to our presenter.
All right. Well, thank you for that warm introduction. And I definitely need to abbreviate my my bio. That was a lot that you guys had to listen to. So I am Elissa Holman, and I feel like I am at home. I am with my people because I spent so much time in the HR space before I decided to go to law school midlife. And so now I've been practicing for about 5 years, but like I said, spent about 20 years in the HR arena. So it's good to be home, good to be with my people. I also want to let you guys know that, like any good lawyer, I have to give a legal disclaimer. So that I'm not advising, this is not legal advice. I am doing a presentation based on very kind of general information that you can use and apply in your own workspace, but not actual legal advice. And so some of the things that we're going to be talking about today, actually many of the things that we're going to be talking about today can easily change. We are in an environment, particularly in HR and in the employment space, where the law is changing rather quickly, particularly in the NLRB, for any of you that practice in an area that, well, it should be most of you, that practice in an area where the NRLB is making some rulings that I want you guys to definitely be aware of. So I'm going to go ahead and get started and share my screen. Okay. Can you guys see that? I hope. Okay.
Yes.
All right. Excellent. Thank you. So the first thing that I'm going to start, I'm just going to kind of ease into the basically like top 10 things that I want you guys to be aware of. And keep in mind too, I'm going to send you guys a PDF. And the way that I drafted and developed this PowerPoint presentation is really for a lot of you as leaders in the HR space to be able to present to your business leadership team. So feel free to take it, use it, just understand that it's not legal advice, and we're in a constant state of flux and the law is changing, but it is something that you can use and a deck that you could use in-house, and I hope that you do. So employee handbook, making sure that you have one and that it's up to date. Having been in the HR space, I know it's like the last thing that you want to think of. It can be very labor intensive. It can be extraordinarily boring, but necessary. And so I just kind of captured some things, and there are quite a few, but if you have a moment, and again, you're going to get this PowerPoint presentation also yourself, there are some very specific areas that I want you to take a look at in your handbook. And if you have not updated your handbook for some time, it is time to do it. And one thing that I will also say about the handbook is that it's really important that you have counsel review your handbook to make sure that you're current with the existing law. There's a lot of things that are changing that are having a direct actual impact on the employee handbook. Specifically, there's a ruling by the National Labor Relations Board on Stericycle, is the name of the case, where it basically it does make it unlawful to, what's the word? It makes it unlawful for the employer rather, to say that the employee can't say anything that might be, bad about the company. They have to be able to protect their rights as an employee to organize. And so this particular ruling, the Stericycle, really is going to make an impact, and it will change how your social media language in your handbook is written. That is something that you really need to make sure of, because before, under the previous National Labor Relations Board, the employers were able to limit some of the things that employees can do, and they can still limit it to an extent, but so long as it doesn't have a perception to the National Relations Board that it is infringing on an employee's rights to organize. So we need to definitely, if you haven't looked at that in your handbook, you definitely need to. These are just some quick hits of things that need to be updated. Making sure that your I-9 policy is captured. If someone doesn't give you the information that you need within the time frame needed, that you have a policy that states that they will no longer be able to be employed until that information is presented. It's also important to have your at-will policy. Make sure that that is looked at by an attorney and that that's captured clearly, that your corrective action policy is in place. Your equal opportunity and anti-harassment policy is in place. And this is something that I always tell people. And I was a plaintiff's lawyer and represented employees for most of my career until I came over to the defense side. And I can tell you that I regularly, and please don't hold it against me that I was a plaintiff's lawyer, but as a plaintiff's lawyer, I would often look at the equal opportunity and anti-harassment policy in the handbook. That was one of the things that I would always look for, and making sure that the right people are captured, or that in the handbook for who to go to, whether it is a general HR department, or a lot of times, sometimes it can be very specific people, and you got to make sure that the people are still working for you. when that happens. And you have to make sure that you understand where you have these different HR practices captured in detail in your policy, because those are going to be some of the things that I would have looked for as a plaintiff's lawyer. I can also tell you as a recovering plaintiff's lawyer that the equal opportunity and anti-harassment policy, I always recommend to my employer clients that we need to have it up front in the policy so that we make sure that it shows that we give it some weight, that it's that important to the employer. And so I would ask that you, if you're looking into updating your handbook, which many of you should, if you haven't, I would want that area moved up in the handbook instead of at the tail end, which sometimes that happens. Making sure that your FMLA policy and ADA policy, it's captured, that it's correct, and that you've captured clearly in your handbook how you count FMLA. Are you rolling backwards? Is it, in the course of one calendar year? Like making sure that you've got that captured in a way that people can actually understand what that means. And sometimes it's best in employee handbooks to give a couple scenarios of how you would apply leave to an employee, so that they understand what that looks like. One thing I would also add as it relates to FMLA and ADA, we always think too, like peanut butter and jelly, like they go together, right? So I would like for all of you to start thinking, if you aren't already, that FMLA and ADA, they go together. They're like peanut butter and jelly. So just because an FMLA runs out for an employee does not mean that the conversation is over. This is often where a conversation needs to occur related to accommodations, related to a disability. So if you can always think about FMLA and ADA as kind of the peanut butter and jelly, and just because you've put the peanut butter on the bread doesn't mean that's over. You now have to look at the jelly side before you make that sandwich. So making sure that you analyze FMLA and ADA together, particularly when someone is coming off of FMLA and has exhausted their FMLA leaves. I see this as a huge risk for our employers, and it happens more often than I can tell you, is that they think that FMLA is over, you're out of time, you got to go, instead of analyzing what accommodations could be made. Is it an actual undue hardship, and going through that interactive process with the employee. So I would just say, kind of for all of you on here, make sure to really pay attention to that, because it is a weak spot that I'm seeing in a lot of my clients over the years. Your drug testing policy. I've recently had a client that was adhering, the drug testing policy was really outdated and not actually what was necessary or required. And so making sure that your policy is updated, that it's current, even if the employer is following current drug testing policy law, if you will. If your handbook reflects something else, that can cause a problem. So making sure that your policies reflect what's actually happening in the workplace. Nursing mothers policy. This is becoming something that I'm a trial lawyer too, so I take cases to trial, and this is an area that I expect and anticipate to see a lot of litigation start to bubble up within the next 1 to 5 years. Making sure that you are familiar with the nursing mothers policy. I can give you, always like to give like a real life example. One of my clients owns multiple restaurants all across the state of Iowa. And one of their servers needed time to pump for her new infant. And what ended up happening is they thought they were putting her in a private space, because oftentimes, right, like in restaurants or bars, like there's not like a big office like my office where they can put a lock on it and shut it down. So they told the server to go into like this little manager's almost closet. And there's also the safe for the business is in this closet. And there's a camera on the safe in the closet with the one chair. And this is where she pumped. again, there was the best of intentions. Nobody was, looking or recording the tape, but nobody ever, took the camera down, took it off when she was in there, and made sure that she had privacy. And that became a pretty significant issue. They also wouldn't let her pump like during the lunch or dinner rush. And that's not how this works. They're able to pump when they need to pump. And so there were some texts that were also going on amongst servers that also became really problematic, which is a whole other topic that we'll get to, which is making sure that, as business leaders, as HR leaders, that you're making sure that your business leaders have these conversations with their employees, and you have them with the business leaders, that these text messages all become fair game once we get into litigation. And so it is really important to be mindful. Just because it's a text, sometimes we use, slang or say things, and it can all be discoverable in the course of litigation, and it is. And in this particular situation, the language was not great at all. It was pretty devastating for my client. And so making sure that we've got a handle on the text messages, but again, making sure that you're accommodating nursing mothers. There's another case involving a restaurateur where they told the one of the servers that she could pump in the bathroom. That's not allowed, not a thing. And again, the manager thought that that was giving her the privacy that she needed. But a bathroom is not a sanitary place for that to happen. And so making sure that you understand the nursing policy, but more importantly, because you're my people, you probably all know these things. Why I'm telling you this is that so that you can go back and tell your leadership team, make sure that they understand the nursing mothers policy and the law that goes along with that nursing mothers policy. Social media and electronics policy. This is where we really have to be careful. This is that case that I was mentioning, the Stericycle case, which basically, and it's a little frustrating because they've basically swung from one end of the pendulum, kind of where it was really employer friendly, to the other end of the pendulum, which is very employee friendly. And it'd be nice if we could just meet in the middle somewhere, but I don't know that that's ever going to happen. So, but in this case with Stericycle, anything that could be viewed as getting in the way of an employee's right to organize is going to be considered an unfair labor practice, a ULP. Okay. And so really having an attorney go through your social media and electronics policy, your confidentiality, it can impact your confidentiality policy. In some cases, it can impact your non-competes and non-solicits. So it's very important that you pay attention to this Stericycle ruling that basically, and I'm just making a general sweeping statement, but Stericycle basically allows, considers that anything that would stifle an employee from moving forward would be considered a ULP. So this is the time to have an attorney look at your employee handbook. Because, and this is low hanging fruit is what I would consider also. So if they're looking for a reason to come after an employer, the easiest way is to look at your policy that hasn't been revised and say, you company have committed an unfair labor practice because your policy is too restrictive on an employee's right to organize. Okay. So that is something that I definitely want you guys to pay attention to. And also making sure that your business leaders and their teams understand business communications and social media, and making sure that they also understand that text messages and emails, if anything were to come, like they need to start texting and emailing like it would show up in litigation. And if you draft something and you're like, oh, if this ever came up in trial, would I be okay with it? Well, you might want to revisit. You might want to really think about that. And if it's something you're fine with, then go ahead, proceed. If not, then I would maybe revisit or have a phone call. making sure that on the handbooks, for some of you, and I know I probably have a lot of people here that manage, from small industries to big industries or big companies. I still think it's important and on an annual basis to get an acknowledgement of the handbook, whether it's been updated or not, making sure that they have access to it, that you've sent a link to it, that they have a paper version of it, and have them acknowledge it each time that on an annual basis. I think that's really important because it also puts the onus on the employee too, right? These are our policies. I'm aware of them. I'm going to agree to these policies as an employee. Okay. Artificial intelligence. Danger, danger, danger. As an employment lawyer, this is something that really does kind of keep me up at night. I can tell you, I'm sure it keeps a lot of you up at night also. But some things that I want you to really pay attention to. I know that there's some tools out there, and I know probably some of you use some of these tools. For example, like an interview, like a first interview, it's like a link and the candidate is answering the questions on their computer, much like I'm doing today. And then the artificial intelligence, goes through the answers that the candidate gave to the questions that are being asked and determines whether the AI determines whether the candidate proceeds or is out. I'm very, very, very concerned about this because I have actually seen this with one of my clients where the AI tool is super cutting edge. It's hot, it's sexy, it's in all media right now as something that businesses should do. But for my client, we have a situation where it is disparately impacting a particular minority population. So by minority population is people that English is a second language, okay? And so sometimes this AI can't understand someone that may have a thick accent, or may not understand if someone has a disability, may not be able to distinguish that, and could disparately impact our uniquely able population. This is something that is really concerning. Artificial intelligence as it relates to recruiting and screening of candidates. I know it's something that sounds enticing, but you have to really be certain that you know what's going on. I can also tell you that the courts have made it very clear that even if you purchase like AI from a vendor, and that vendor hasn't done necessary, or the vendor tells you, we've done all of our due diligence. It doesn't just, we've tested, it doesn't disparately impact anyone in a protected class. And let's say that you believe them. Let's even say that they have a waiver that holds the company harmless. That's not something that's not going to be permissible. That's not going to be a defense in these cases. So even if a vendor is saying, you can be held harmless if you take this, we'll take the brunt of it. You employer will still be on the hook if it does disparately impact a particular population. It can also, and I'm talking about disparately impact like a protected class in general. And again, with disparate impact, you do not have to have ill will or a mean intention. It just actually just impacts that particular group based on how it's designed. So that's something that I really would want everyone to pay attention to specifically. It can also obviously have a disparate treatment impact, and that can happen when one person realizes that they were immediately kicked out, or scanned out or screened out from an interview. They can also take action on their own to assert disparate treatment. I mentioned the ADAA implications for our uniquely abled population. And I would just really ask that you consult counsel and know the risks of AI. again, this is super hot. Like I said, everybody wants to do it. It's, and it does have some good uses. I just have a lot of hesitancy around AI and the recruiting component in the HR arena. And I would just make sure that you review the materials. And if you're not familiar with what the vendor is providing, it may often, I would recommend that you get an attorney. You can certainly call me to review the tests that they've done to make sure it's not been disparately impacting other protected classes, and to advise you accordingly. I wouldn't just take it without having an attorney take a very close look at the material. This is also an area, and I'm sure all of you are familiar with the EEOC. They have their strategic enforcement plan that they put in place for 2024 and 2000 through 2028. So these are the things that the EEOC, which often trickles down into our state agency, our Iowa Civil Rights Commission, or your local agencies even. And these are the areas that they have said that they're going to focus on from 24 to 28. And so they're going to be really working on focusing on preventing discrimination, specifically targeted discrimination, bias and hate directed at religious minorities, including anti-Semitism and Islamophobia, racial ethnic groups, LGBTQ+. They also, and they have 3 priorities. The second priority is expanding the vulnerable and underserved worker priority to include additional categories of workers who may be unaware of their rights under EEO laws and may be reluctant or unable to exercise their legally protected rights. So to me, that sounds like they're going to be, really targeting people that, people that might be, picking fruit or working on the farms, that might be immigrants or might, be undocumented workers. They still have rights. And so I think that sounds to me like what they're going to be looking at. Their third priority, and again, this reiterates what I was talking about for the nursing mothers, updating the emerging and developing issues priorities regarding protecting workers affected by pregnancy, childbirth, or related medical conditions, including the Pregnant Workers Fairness Act and other EEO laws. They're also looking at discrimination that's associated with long-term effects of COVID-19 symptoms. And last but not least, they're looking at technology-related employment discrimination. So they are going to be hot on the tails of employers with these AI tools to see if it impacts not only the employment population, but also like the consumer population. So it's something that I would pay very, very close attention to during this time. Employee training. Making sure this is just some basic stuff that I would look for again as a plaintiff's lawyer. So I thought it might be good now that I'm on the good side of things to give you some tips on some things that I would really call out if I were to be on the plaintiff side still suing an employer, for example. So job descriptions. I would be looking at a job description. Is the job description does it actually describe what the job does? Or is this, a job description that the business has had in place for the last 10 to 20 years that is totally different than what the reality of the job is? And again, I get it, right? Like in the HR space, we're not in the money making business. It costs money to have HR, so it's going to cost money to have job descriptions updated. But this can be a real problem, particularly when it comes to like terminating someone who wasn't doing their job, right? When the job description, based on when they applied for the job, was completely different in writing than what the actual job was. Onboarding is a hot topic. Make sure that, listen, and like I said, I know we've got people from small business to big business, our budgets are all different, But we can all do these things. We can all onboard our people, our new candidates and employees in the right way. That can be for our smaller businesses, having a checklist of things that you need to go over, and then building from that checklist as you onboard a new employee to think it'll come to mind. Oh, we need to go over this too. I got to add it to my list. Having a checklist and just making sure that you are onboarding the person in the right way and setting them up for success is really key. If you're on the big side of business, they usually have onboarding plans as well, making sure that that onboarding is occurring. And you as HR people are often not the people doing the onboarding. You get the tools probably ready and the checklist or what have you, and then give it to your business leaders to properly onboard. You've got to inspect what you expect. You have to make sure that these leaders are actually onboarding the employees in the right way, because the best of intentions can be great, but if they're not followed, as you all know, it can be a problem. So making sure, and these are things that are highly litigated areas: job descriptions, onboarding, continuing education. And when I'm talking about continuing education, what I'm really talking about is making sure that your leaders, your managers, your supervisors, that they are, up to date on the onboarding practices and why it's important, why it matters, and the impact that it can have. Continuing education also makes sure that, you're not discriminating against people when you're providing continuing education opportunities. That doesn't come up as much, but it's something always to be aware of. And making sure that they acknowledge the training. A lot of times there will be like writing on training documents or onboarding, but there's no signature from the employee or their supervisor manager that's onboarding them. And that can be a real problem when it comes down to litigation. So that's, again, something that I would really recommend that if you don't have people initial or sign, it can backfire in a trial, for example. And confirm employee maintenance of credential and licenses. This has become an issue, and it actually did become an issue in a case involving a nursing home, okay? Where there was, and this was some time ago, but there was a case where an elderly person had actually become quite injured and was actually in a coma. And there were some allegations that the worker or that the employee was abusing this particular, patient/resident. And what was discovered during this time is that the credentials at this nursing home, the licenses were not up to date. And you got to make sure that there's some sort of practice or tickler in your file to make sure that credentials and licenses are up to date, that you're following up on it, and that you're making sure that individuals are credentialed and licensed even after you've hired them, and that it can be even a few days it can cause of not being credentialed or licensed. In those few days, something could go wrong. I mean, there's always, I hear about people, I kind of like make it analogous to like if you don't pay your car insurance and are without a car insurance for a couple days, those are probably going to be the days you're going to get in a car accident. And it's kind of the same thing that I would think of when I talk about credentialing and licensing of employees, making sure that you've got a system or a plan in place to manage those licenses and credentials, because it can be a very significant problem in more ways than one. Documentation. Listen, I know I'm preaching to the choir because you're my people. But this is, again, hopefully you can take this deck and tweak it and make it your own and present to your own business leaders. But documentation is critical. Contemporaneous documentation is preferable. Making sure, and sometimes, people get like so wound up about documenting and I don't have time, and you can email yourself a documentation of a conversation, a verbal conversation or a verbal coaching that you may have had with an employee or an associate, and send it to you in HR, or they can send it to themselves just so they have an actual record of it. Taking it during or after the conversation is generally preferable, but if the manager or leader or employee forgets to do that, taking documentation as soon as you remember is also really good. Support for discipline. So a lot of times I see write-ups that talk about, you've done X, Y, and Z, or you haven't met these sales goals, but doesn't necessarily have attached the actual sales goal worksheet as the supporting documentation. I think it's important to have support for the discipline and the impact that it can make. If you have it, and listen, I understand there's cases where there just isn't, anything to add to it. But if you have support for the discipline, that you absolutely keep it with the corrective action that you might be taking against an employee. That's going to be something that's really important. And I can't tell you how many times I get a call from a client that says, hey, I want to fire someone. And I'm like, okay, well, where are we at? Have you had conversations with them? Oh, they've been terrible. We should have let them go, 2 years ago. Okay, well, send me over the documentation of what's happened and where we're at. And then there's no documentation. And what's problematic with that is that in most cases, I'm going to have you start to, have the conversation, give them time to correct, and it just slows down the process. So I know these conversations are hard. I know I'm preaching to the choir, but this is really, again, for you to take to your HR, to your business leadership teams. Making sure that you hold your people accountable and having those transparent conversations related to performance will really help you when you get to a point where you may need to terminate someone. And sometimes too, people just really, I've seen leaders sometimes not be able to give the direct feedback or the direct coaching, and they kind of speak in riddles and kind of dance around the subject. And the employee doesn't really understand what it is they're telling them. This isn't always the case, but it can be the case. And so I think it's really important that we help our leadership teams and our managers to have these conversations. I know they hate role playing. Everybody hates role playing, but sometimes sometimes you need to. And these are really good examples of times that you need to practice it. So when it happens, you're all set and the leader's all set to have that conversation. Memorialize verbal conversations. Again, this is one of the things where someone will call me. I've had these conversations over and over and over again. Okay, well, when did you have it? What was discussed? And then there's just no documentation of when it happened and what was discussed. I'm not saying that a verbal needs to be in writing to the employee, but you should be documenting it somewhere in your own system for your own record. But for the love of all things good, please do not ever record conversations. This is a real problem. And I have seen it. Like I said, I'm a trial lawyer. I've gone to trial and I've seen this go real bad, where they think, the employer thinks that, oh, I got you, I'm going to record the whole conversation. And then the plaintiff's counsel is going to edit it and only use snippets of it. And it's going to backfire in a profound way. And it often does. So resist that urge to have to have you guys record the conversation. And I, wouldn't let the employee have the conversation. If they insist on it, I would talk to counsel before you agree to it. But another thing that I also would tell you guys, a lot of times it's not the employer that is the problem. It's the employees that are recording the conversation. And so making sure that obviously you as HR professionals know this, but the leaders understand that you just kind of have to go under the assumption that you are being recorded, because they probably are in a termination, especially if the person knows that it's coming or that things are going south fast. And so making sure that leaders and managers, really temper the words that they use. And again, this is a good opportunity for the leadership team and managers to role play with you guys so that they are prepared to get the right words out and how to respond, in different situations. Because a lot of times, like I said, it's the employee that will record. Performance evaluation. Of course, annually, of course, we need it to be acknowledged. Again, this is something that's really important, that there's an annual performance evaluation, that there's an acknowledgement. And one thing I would tell you that I see more often than not is that the performance plan reflects the actual performance of the employee. I see so many times, oh, this employee was terrible. They never performed. They were terrible with the client. They weren't a team player, and on and on and on. And then I'm like, okay, send me over, let's look at their performance evaluations. And you would think that this employee was like going to be the next CEO based on some of the notes and the ratings that that poor performing employee received. And this is where it also becomes a big problem if a case gets litigated, because as again, a recovering former plaintiff's attorney, I can tell you, I use this multiple times, the performance evaluation, and the fact that, a lot of the times the employees had glowing evaluations and then all of a sudden they're the worst and they get fired. And what I know, is that it's just managers and leaders not taking the time to actually, document real performance and put in coaching opportunities there. Investigations. Obviously, taking complaints seriously, know and follow, your retaliation policy, making sure that all the employees understand that there's no retaliation policy when the investigation happens, that you take immediate action. Timeliness is like next to godliness. Making sure that you get on the investigation. And a lot of times this is HR. And I know that a lot of times you have to get the business on board with it, but making sure in these instances, this is where HR really needs to take the wheel and make sure that everybody's communicated. There's no retaliation will be tolerated, that there's immediate action, that there's a neutral party investigating the investigation. I get hired to do investigations. Other lawyers get hired to do investigations. If you don't have a neutral party that's like trained to know how to do some of these investigations, you can call your attorney and they could possibly do it. Or you can call me, or you can, also Google. There's some people that have been, that's all they do is investigations, and you can get a neutral party to do what they need to do to get to the bottom of it. If you're doing the investigation, HR, make sure that you're listening to understand, which is kind of what you do every day. So this is important, but if it's someone else doing the HR investigation, or if the business is insisting that they're going to have somebody do it, it's going to be really important that you kind of oversee that investigation, and make sure that they understand the ground rules. Take notes, obviously, gather the specifics. And here's where I really see things go just off the rails, is communicating the conclusion. So this is where a lot of lawsuits happen. I can tell you that. There's, they complain of being treated disparately or differently because they're a female, or, because they're a person of color, whatever it may be. And then the employer says, we're going to look into it. There's going to be no retaliation. We're going to get, to the bottom of this. And so the employer does look into it. And the employer comes to a decision on, whether something's founded or not founded, whatever it may be, and then, wraps it up. But what happens is they don't close that loop. And this is where the problem comes in. You can't obviously tell an employee, the details of the investigation, and and in some cases not the outcome, but you can communicate, we've concluded our investigation. Thank you for, being brave enough to come and bring it to our attention. We are addressing it. And we just wanted to let you know that it has concluded, and we will take the necessary next steps, and let us know if you receive any retaliation. That won't be tolerated, and close that loop. And this is like so important, because often I see employers have completed the investigation, but they haven't gone back and closed the loop. And so you have this employee hanging out there that thinks that absolutely nothing has been done, or that you just didn't care, or that it hasn't concluded. And obviously, in many cases, you're not going to be able to go into like the action, in most cases, the actions that were taken against, whoever is accused. But it's important to close that loop because it helps the associate understand that you care about them, that you care about what has been brought to your attention, and that you're doing everything you can to resolve it and bring it to a conclusion. Corrective action, I'm going to kind of breeze through that. You guys know this, making sure that you're consistent. But the most important piece on corrective action is if you set up, if leadership, or if you set it up for leadership, or you're doing it yourself, if you say you're going to follow up and check in with the employee once a week at a certain amount of time, you better check in with them once a week at a certain amount of time. Because if this employee fails and in the documentation you say you're going to meet up with them once a week and you don't meet up with them once a week, and then you end up firing them, then it looks like you set them up for success. So if you have to change the one-on-one, totally get it. But those are the things that's something that will come up in litigation also, and making sure someone acknowledges the next steps. Termination. The main thing here is employees should not be surprised unless it's like one just completely outrageous, egregious action. An employee shouldn't be surprised in most cases when a termination comes, and that can be, transparency. Maybe they're in the wrong job. Maybe this isn't the right place for them. But if you're having the right coaching conversations and taking the right actions, whether it be leader or HR, the employee in most cases shouldn't be surprised, and may even be relieved. Oh, and if you do think an employee is if you think, oh, she's gonna hire a lawyer, I know it, or he's gonna hire a lawyer, I know it. If you know in HR, probably more than anybody in the company, whether somebody's going to take legal action or not. This is an opportunity where you might want to press the lever of considering a severance agreement to get the employee some, income in order to waive any rights to litigation later. And sometimes maybe they don't even have a case, but the cost of defense sometimes in these things is often more than what an employee would have taken had you just given them, a $2,500 severance package. So always think about that when you're thinking about an employee and you're like, oh, I know they're going to lawyer up. That is something that I would 100% look into. There are a couple additional slides in here that I'm going to stop just for that you'll see, that you can look through. And I don't think I need to explain them. You'll understand them. And if you have any questions, I'm always here to answer your questions or to answer your emails. So feel free to do that. So I'm going to turn it over to you, Joanna.
Thank you very much for that wonderful information. So now, if you have any of your questions, please turn your mic on and ask the question. Any questions?
Just curious, what part of the handbook should be talked about at orientation?
I mean, I would go through at orientation, I would go through your, for sure, your equal opportunity and anti-harassment policy. I would make sure that is something that's discussed. If you're a drug testing company, that also needs to be discussed and communicated with so that they understand that. And right now, I will tell you, I am very concerned, and we can save this for another day. The National Labor Relations Board is really gunning for employers right now. And I have a lot of concern about that. So I would go over like the social media policy, but make sure that they understand that this is in no way infringing on their rights, as an employee to organize. So I would, depending on what you have in there, maybe go over that, but you have to be really careful because of the National Labor Relations Board. They're just looking for these ULPs right now. and then those are the main things, probably the at-will policy, equal opportunity, anti-harassment policy, drug testing policy as applicable, and social media, electronics policy, but you have to make sure to say, like, whatever your policy is, you're going to want to get a lawyer before you start having that conversation with your employees to make sure you're not committing an unfair labor practice.
Any other questions?
Elissa, this is Bobby Joe. I was just curious if you had a sample social media policy that you could share with us or recommend what should be included and what shouldn't.
So I'm actually working on that right now because I've had to go in and change so many. I'm working on a template. It's really hard to send a template, just a generic template out, because it always, handbooks are generally written specific to an industry or business. So I don't have a template to send out now, but if someone wants to get that changed, they can certainly reach out to me or to their own counsel to have that updated and changed.
Any other questions? Well, thank you very much, Elissa. This was very informative, and I know we're going to take a lot away from this presentation. For all of our attendees today, you will receive an email in the next couple of days that will have recertification credit information available, as well as additional information about the program. Thank you so much for attending, and thank you again, Elissa, for this wonderful presentation.
Thank you.